The highest court in the land is now looking into overturning Hawaii's strict gun laws.
Major Supreme Court ruling on New York's concealed carry regulations.
The ruling could jeopardize similar laws in 5 other states.
Imagine living in a country where your constitutional rights literally disappear the moment you cross an invisible line on a map, where government officials openly defy the highest court in the land, betting that you won't fight back, where bureaucrats treat your fundamental freedoms like privileges they can revoke at will. Well, that nightmare scenario just came to a crashing halt, and the legal earthquake that's about to reshape America will leave anti-gun politicians scrambling for cover. The trap that state officials never saw coming. Here's where this story gets absolutely fascinating and reveals just how brilliant constitutional lawyers can be when they're playing chess while their opponents are playing checkers. The case that just broke everything wide open wasn't won through traditional legal arguments or passionate courtroom speeches. It was won through a carefully orchestrated trap that state officials walked into with their eyes wide open. The plaintiffs and the federal government didn't just file legal briefs, they set a legislative snare so elegant that Hawaii's attorneys literally argued themselves into a corner they couldn't escape from. During proceedings at the Ninth Circuit level, Hawaii's own legal team made what seemed like a routine procedural argument. They told the judges that this was just a pure Second Amendment question, and that no further evidence needed to be developed at the lower court level. Those words would come back to haunt them in ways they never imagined. When Hawaii later tried to delay Supreme Court review by claiming more lower court development was needed, both the plaintiffs and the federal government threw those exact words back in their faces. The state had already conceded that nothing else needed to be examined. They had essentially admitted their own case was ready for final judgment. This wasn't just a legal miscalculation. It was a masterclass in strategic litigation that reveals how the most significant constitutional victories often happen not through dramatic courtroom moments, but through methodical preparation and opponents' own words becoming their downfall. The federal government's stunning betrayal of blue state politics. But here's where the plot takes a turn that nobody saw coming. A development so unexpected that it fundamentally changes the power dynamics of Second Amendment litigation forever. The Department of Justice, under new leadership, didn't just stay neutral in this case. They didn't just file a lukewarm brief offering mild support. They came out swinging with language so forceful, so uncompromising, that it reads like a Second Amendment advocacy group wrote it. In their amicus brief, the federal government declared that Hawaii's restrictions represent a near-complete ban that is flatly inconsistent with Supreme Court precedent. Think about the implications of that language. The federal government, the same entity that blue state politicians expect to back their gun control efforts, just called their flagship legislation unconstitutional in the strongest possible terms. This represents a seismic shift in federal gun policy that extends far beyond this single case. When the Department of Justice throws its full weight behind striking down state gun laws, it signals to every federal court in America that the executive branch expects aggressive enforcement of Second Amendment rights. Federal prosecutors, FBI agents, and federal judges are all now operating under the clear understanding that the administration views state gun restrictions as constitutional violations worthy of immediate challenge. The psychological impact on state legislators cannot be overstated. For decades, blue state politicians have operated under the assumption that federal power would either support or ignore their gun control experiments. That safety net just disappeared, and the legal landscape has fundamentally shifted beneath their feet. The circuit split that's about to explode across America. The legal drama gets even more intense when you understand the constitutional crisis that's been brewing in federal courts across the country. We're not just talking about one rogue court making a bad decision. We're looking at a fundamental disagreement between major federal circuits that has created a patchwork of conflicting constitutional interpretations. The Ninth Circuit, covering much of the western United States, ruled that states can essentially ban concealed carry on most private property through catch-all restrictions. Meanwhile, the Third Circuit reached the exact opposite conclusion, finding that such blanket prohibitions violate the Second Amendment. This isn't a minor technical disagreement. It's a constitutional crisis where identical actions are simultaneously legal and illegal, depending on which side of an arbitrary geographical line you happen to be standing on. Circuit splits like this create what legal scholars call rights geography, a situation where your constitutional protections change based on your zip code. Imagine if your right to free speech, your right to due process, or your right to religious freedom varied depending on which federal circuit you lived in. The absurdity becomes obvious immediately. Yet that's exactly what's been happening with Second Amendment rights. The Supreme Court's decision to take this case signals their recognition that this constitutional patchwork cannot continue. When federal circuits reach opposite conclusions on fundamental constitutional questions, the Supreme Court has no choice but to step in and establish uniform national standards. The question isn't whether they'll rule in favor of Second Amendment rights, it's how sweeping that ruling will be. The legal strategy that breaks 85 years of precedent. Here's where legal history buffs will find their minds blown. This case represents something that hasn't happened in the Second Amendment context for nearly 9 decades. The Supreme Court has a well-established pattern of avoiding what lawyers call interlocutory appeals, cases that come up while lower court proceedings are still ongoing. They prefer to wait until all the procedural dust settles before weighing in on constitutional questions. But emergency Supreme Court intervention in ongoing cases is extraordinarily rare, reserved for situations where immediate constitutional harm is occurring and waiting for normal legal processes would cause irreparable damage. The last time the court used this type of emergency power for Second Amendment issues was in 1939. We're talking about an 85-year precedent break that signals just how seriously the justices view this situation. This emergency intervention sends a message to every federal court in America. The Supreme Court will not tolerate further delays or procedural games when it comes to Second Amendment violations. Lower courts that have been slow-walking gun rights cases or finding creative ways to avoid enforcing Supreme Court precedent are now on notice that emergency review is available for the most egregious violations. The speed of this intervention also suggests something else. The justices are confident in their legal analysis and aren't concerned about rushing to judgment. When the Supreme Court moves this quickly on a constitutional question, it typically means they view the legal issues as clear-cut rather than requiring extended deliberation. The private property revolution that changes everything. The specific legal question the Supreme Court will address cuts to the heart of how property rights and constitutional rights intersect in modern America. Hawaii's law essentially created a system where your Second Amendment rights disappear the moment you step onto any private property open to the public, unless you can somehow obtain express permission from the property owner. Think about what this means in practice. Every shopping mall, restaurant, office building, hotel, gas station, and retail store becomes a potential constitutional dead zone where your right to self-defense simply evaporates. You could have a valid concealed carry permit, perfect legal compliance in every other respect, and still become a felon simply by entering a grocery store whose owner hasn't explicitly told you that firearms are welcome. This creates an impossible legal maze where law-abiding citizens must somehow navigate a constantly changing landscape of property-specific permissions while criminals ignore these restrictions entirely. The absurdity becomes even more apparent when you realize that property owners often have no clear way to grant such permission, no standardized system for communicating their policies, and no legal protection if they make the wrong choice. The Supreme Court's willingness to address this question suggests they recognize that constitutional rights cannot be subject to the whims of property owners or the bureaucratic preferences of state legislators. The Second Amendment either means something concrete and enforceable, or it becomes meaningless in practice. The domino effect that will reshape American gun laws. The implications of this case extend far beyond Hawaii's specific restrictions, potentially triggering a cascade of legal challenges that could reshape gun laws across America. States like New York, California, New Jersey, and others have implemented virtually identical restrictions, betting that federal courts would uphold their creative interpretations of Supreme Court precedent. That bet is about to be called, and the stakes couldn't be higher. A strong Supreme Court ruling in favor of Second Amendment rights won't just invalidate Hawaii's law, it will provide a legal template that gun rights advocates can use to challenge similar restrictions nationwide. We're potentially looking at a domino effect where decades of accumulated gun control legislation gets swept away by a single Supreme Court decision. State legislators who thought they could cleverly circumvent Supreme Court precedent through creative lawyering and procedural games are about to discover that constitutional rights aren't subject to legislative creativity. The Supreme Court has shown increasing impatience with what they clearly view as deliberate defiance of their previous rulings, and this case gives them an opportunity to send an unmistakable message. Legal experts are already predicting that this ruling could establish the strongest Second Amendment precedent in American history, potentially creating a legal framework that makes future state restrictions much more difficult to justify. The court isn't just going to rule on Hawaii's specific law. They're going to provide detailed guidance on how lower courts should analyze Second Amendment cases going forward, the constitutional earthquake that's about to hit. The timing of this case couldn't be more significant for the future of constitutional law in America. The Supreme Court is preparing to issue what could be the most comprehensive Second Amendment ruling since the landmark decisions that first established individual gun rights as fundamental constitutional protections. This isn't just another incremental legal victory or narrow technical ruling. We're looking at a potential constitutional earthquake that could fundamentally alter the balance of power between state governments and individual rights. The question isn't whether this will impact gun owners, it's whether you'll be prepared for the legal and political transformation that's about to sweep across America. The Supreme Court's decision to fast-track this case through emergency procedures signals their recognition that immediate constitutional harm is occurring and that normal legal processes are inadequate to address the scope of the problem. When the highest court in the land abandons its usual cautious approach in favor of emergency intervention, you know something extraordinary is about to happen. The legal strategies, political alliances, and constitutional principles we've uncovered in this case reveal that America is on the verge of the most significant Second Amendment victory in our nation's history, one that could restore constitutional rights to millions of Americans while establishing legal precedents that will protect those rights for generations to come.